or CMR 8th National Moot Court Competition 2022.
We have here with us today 4 distinguished judges. Honorable Mr. Justice Shivashankar Amaranavar, Honorable Mr. Justice P.N. Desai, Honorable Mr. Justice A.V. Chandrasekhara, and Honorable Mr. Justice B.A. Patil. We request the audience to kindly switch off your mobile phones in order to have an uninterrupted session. Thank you.
Counsel seeks permission to approach the podium.
Please this honorable court, before the commencement of the issues and the facts of the case, would it be preferable if the counsel addressed the bench together as your lordships and individually as your lordship? Lordships. Deeply obliged. Would the bench
The
prefer...
practice that we adopted, they adopt in constitutional courts. When a bench consisting of several lordships.
Yes, sir. Thank you. Would the bench prefer a brief synopsis of the facts of the case?
But
In this particular case, the issue is under a public interest litigation which has been initiated by Mr. Venkatesh Ramasamy and Ms. Pallavi Mistry versus 3 entities: the Federal Reserve Bank of India, the Metafax Data Analytics India Limited, and the Union of India. In this case, MFDAI is a public unlisted company whose subsidiary is incorporated under the Companies Act of 1956. Now, the facts of the case will be split into 2 folds, according to the petitioners. The first is with regards to Mr. Venkatesh Ramasamy, who was a non-resident Indian. He was a professor who was pursuing an agricultural course at the University of Dubai. His annual income was at around 22,500 dirhams. And it is to be noted here that he was an upstanding individual with no loans or no credit cards. Must also be noted that during 2019, Mr. Ramasamy was invited to attend a conclave by the government of Bangalore. And when he got to Bangalore, he wanted to avail a car loan, purchase a car. But to his surprise, he noticed that his loan was rejected by all commercial banks and NBFCs, most of them. To whichever banks he applied, those banks rejected his application. He got to know that this was because his credit score was -1, which represented the lack of a credit history. The lack was because he did not have any loans or credit cards in the nation. Now, therefore, this is Mr. Ramasamy's case. Going to the second petitioner, Ms. Pallavi Mistry. Ms. Pallavi Mistry is a public-spirited individual. She's a social activist. She had attempted to avail a car loan, and she noticed at a subsequent date that due to the fault of the bank, on-time EMI payments that was made by her were recorded to be with a delay and to be lesser in sum. And this faulty information was considered by the credit information company, which is Metafax in this particular case, to formulate her credit report. Now, in that particular case, when attempting to rectify the information given to the company stated 2 points. Number 1, information regarding rectification must only be through the nodal officer appointed by the bank. And number 2, that the disclosure of the procedure to rectify will not be revealed by Metafax data to the consumer. Now, these two have joined together to espouse the cause not just of the petitioners but also of the farmers and the members of the marginalized sections of society. And a letter was drafted, a detailed report was drafted to the Chief Justice of the Supreme Court. This letter was converted through suo motu cognizance to a public interest litigation, which is being argued here. If the facts are understood, the counsel would like to proceed to the issues. Deeply obliged. There are 4 issues in this particular case. The first issue is with regards to maintainability of the petition. The second issue is with regards to the creditworthiness of the stakeholders involved in the litigation. The third is with regards to the data privacy principles, which have been violated here. And the fourth is with regards to the directions issued by the Federal Reserve Bank of India with regards to the policies of the credit information companies. Issues number 1 and 4 will be dealt with by the first counsel, while my co-counsel will be dealing with issues 2 and 3. Shall the co-counsel begin his arguments? The first issue will be with regards to the maintainability of the case. It is argued here that this petition has been drafted through a letter filed before the Chief Justice of the Supreme Court. And this letter was converted into a public interest litigation since there was prima facie evidence of violation of fundamental rights. And this was upheld in the Doon Valley case. The Lordship, the Council also cites the case of Indian Bank Association versus Devkala Consultancy, wherein it was held that even if there was a private start to a litigation, if the court finds to be public issues within the litigation, then public interest litigation can be filed, which is the case here. Even though the second petitioner's infringement was private in nature, since the nature of the infringement was public, and since the company which caused the infringement was a protected custodian of the credit information of several consumers in the nation, this was of a public nature and it was converted into a public interest litigation. The Council would like to cite the case of State of West Bengal versus Union of India, which states that policy decisions of the Reserve Bank of India can be questioned before the court of law if those policy decisions are violative of the fundamental rights guaranteed to individuals. Both councils, through their arguments, will establish how Articles 14, 19, and 21 of the Constitution are violated through both the actions of the Credit Information Company as well as the directions issued by the Federal Reserve Bank of India. The Council also cites the case of Romesh Tapar, wherein it was held that it is the duty of the court to protect the rights of the individuals, especially those of the marginalized sections of society. And therefore, it is the humble submission of the Council here that this particular petition must be held maintainable, must be heard by this bench. Moving on with the leave of the bench to the fourth issue. The fourth issue is with regards to the directions issued by the RBI and the policy, the internal policy of the credit information companies. The Lordship, a brief perusal of the facts would reveal that there are 4 private credit information companies. These companies are registered under the Companies Act. However, the act which governs their functioning is the Credit Information Companies Act of 2005. All information, all directions, and all policies issued by the RBI with regards to their management is under this particular statute. Specifically under sections 10, 11, 36, and 37 of the Credit Information Companies Act. If the Act is placed before the bench would refer. Your Lordships, the first contention, this particular issue will be dealt with in 3 folds. The first fold is with regards to excessive delegation of the FRBI to the credit information companies, number 1. Number 2 will be with regards to the legitimacy of the circulars issued in this regard. And fold number 3 will be with regards to the excessive discretion that has been exercised by the credit information company. Moving to the first fold. The Lordships, the Council will be dealing with section 15 of the Credit Information Companies Act. If the bench could refer to that section.
Page 10.
Yes, Your Lordship. This particular This particular section deals with credit institution being a member of a credit information company. And if I could read the wordings of this particular section for the benefit of the bench.
Yes.
The first clause, Your Lordships, holds that every credit institution in existence on the commencement of the Act, before the expiry of 3 months from such commencement, or within such extended period, as the Reserve Bank may allow on its application, shall become member of at least one credit information company. Consequently, Your Lordship, the Council would like to direct the attention of the bench to page number 71, apologies, page number 74 of the compendium. The compendium will be provided by the court officers shortly.
And 4?
74 of the compendium, Your Lordship, they are taking
Oh, you don't. Oh, thank you. Yes.
The Lordship, first point to be noted here is that this is a notification issued by the RBI. This notification has been issued under section 10 of said Act. Section 10 deals with the RBI's power to frame policies of credit information companies. And section 11 deals with issuing directions. That is also being considered over here. The second point to be noted in this circular is that this circular, much like all other circulars relating to the Act, deals with all scheduled commercial banks, including RRBs, which stand for Regional Rural Banks. All India notified financial institutions, which include non-banking financial institutions, which include institutions such as NABARD, and all credit information companies. Point to be noted here, from a brief perusal of this notification, it is seen that it is made a mandate that all credit institutions, including such and such classes of institutions, should be a member of at least one credit information company. Your Lordship, the contention of the Council is that the word shall, given in the wordings of section 15 of the Act, has been misconstrued by the FRBI to represent a mandatory provision. It is the contention that this must be made a directive provision based on two case laws. The first one is with regards to the state of Uttar Pradesh versus Manbodhan Lal Srivastava, where it was held that unless the outcome of a statute is changed if the section is not punctiliously followed, then in that case the section need not be considered to be mandatory in nature. Similarly, in the case of Shantilal Mirari versus State of Punjab, it was held that a section can only be considered to be mandatory if, number one, there is conspectus of consequence, and number two, there is purpose of prescription. In this case, having not satisfied either of those tests, this particular section, if considered to be mandatory, would be in violation of both these case laws, and therefore it is the contention of the Council that this section cannot be deemed to be mandatory.
So you mean to say that clearly because the consequences are not contemplated, the mandate of the auxiliary verb shall will have to be just ignored.
Yes, sir.
Or it whittles away on its own.
Yes, sir. Not ignored, Your Lordship, but to be relaxed in this particular case. If the Lordships do not have any other queries, the Council would like to move on.
Okay.
Keep your attention. Moving on to the second sub-issue. This is with regards to the legitimacy of circulars issued. Now, the Council would like to request the bench to refer to page number.
No. See, so far as the circulars are concerned, they do not overtake the statutory provisions. But if statute itself makes provision for issuing circulars, statutory circulars, if the authorities are empowered under statute to issue circulars.
Yes, Your Lordship.
Then, when such a circular is being issued, quoting to section 10,
yes,
I think would it not be a relevant piece of document which will have to take a note of?
Your Lordship, the Council will be dealing with this sub-issue, wherein the Council will contend that this particular circular, the circular that the Council will be citing right now, the circular has not considered all facets of the situation. And as per the case of Dharani Sugars versus Union of India, circulars not considering all facets are bad in law. The circular in question, the Lordships, is in page number 71 of the complaint.
Is this the complaint?
Yes, Your Lordship, that's
Okay. Consumer Bureau, Commercial Bureau.
yes, Your Lordship.
Yes.
So a deep perusal of this format, which I quote,
Yes.
is the only uniform data format for credit reporting that the RBI has issued yet. From 2006 until 2022, this is the only format based on which credit score must be calculated. It's to be noted here.
This is the benchmark.
This is the benchmark. This must be followed by all credit information companies.
Okay.
But here it is split into Consumer Bureau and Commercial Bureau. If the bench could purvey the determinants based on which credit score must be calculated, it should be seen here. It should be seen here that there is no provision which saves the application of this particular format from farmers or sections of society or microfinance institutions or any other form of agricultural related credit schemes. For instance, Your Lordships, the Kisan Credit Card Scheme, which was implemented in 1999. Such a credit card scheme is linked to the bank accounts held by the farmers with cooperative societies and banking institutions. This will be through such banking institutions, and such institutions have been made a party under such notifications issued under the Act. Therefore, if the credit score of a farmer whose activity is a seasonal activity, who would not necessarily have a credit history of any sort, is taken into consideration, then as per this format, he will get a credit score of -1. That is no history. A farmer will be disallowed from availing a loan from any financial institution. This is simply absurd, Your Lordship. The government implementing such schemes has been violated by a statutory body of the government. This is the point being made by the council here, and the legitimacy of the circulars issued with regards to the CIC, which are very, very minimal in number, very minuscule in number, are all not considering the complete facets which are existent in each case. Therefore, they are bad in law. It's the contention of the council. Your Lordships, circulars have binding effect, as was held in the case of Central Bank versus Sharad Rice Industries. Since the circulars have binding effect, the CICs are bound to follow them, and the banks and the consumers who come under that are also bound to follow them. Therefore, such circulars which are not complete, which are inaccurate and arbitrarily formed, are forced to be followed by banks and the consumers. Therefore, such circulars should not be legitimized by anybody, regardless of the statutory body of the government. Your Lordship, it is also the contention of the council that there should be no...
Mr. Council,
Yes, Your
whether
Lordship.
you have challenged those circulars before this,
Your Lordship, my pardon.
whether you have challenged those circulars before this bench.
Yes, Your
You are
Lordship.
not, you see your prayer.
Yes, Your Lordship. Yes, Your Lordship.
You read your prayer. What is your prayer? Whether any such direction can be issued by this court.
Yes, Your Lordship. The prayer of the court is that... yes, sir. Your Lordship, the fourth prayer...
No. You have not challenged those circulars.
Your Lordship, the circulars are pursuant to the sections which are contained within the Act.
Yes, we know that.
Yes, sir.
So until and unless this is struck down,
Yes,
that it will be in force.
Your Lordship, the circulars that have been issued until now need not be struck down. However, the circulars that have been issued until now
So
do
do
not
you
consider
mean to
law.
say that the circulars issues are valid?
No, sir.
That-
They are invalid. However, the court has the power and authority to issue directions to the RBI to issue more pertinent circulars. That is the prayer made in the fourth argument.
No. That's not your prayer.
Your Lordship, the fourth prayer, if I'm not wrong, is that the present credit score policy of the FRBI is not permissible under law and request the body to frame more specific guidelines. That is the prayer made. If
Okay, anyhow, being a constitutional court invoking Article 32 of the Constitution of India,
Yes, Your
we
Lordship.
can deal because it's a petition by a common man.
Yes, Your
So
Lordship.
he may not be knowing all the nitty-gritties of the law.
Yes,
Yeah,
Your
we can consider that they all will fall well within the power of this court.
Yes,
This is
Your
an extraordinary power vested under Article 32 of the Constitution.
Absolutely.
We will go further. We'll definitely consider whether the points you have raised are tenable or not.
Deeply obliged, Your Lordship. Your Lordship, on that point, the council would like to request that the bench refer to section 31 of the Act, of the CIC Act.
Yes.
Your Lordship, please bear with me while I read the wordings of this section. Bar of jurisdiction. No court or authority shall have or be entitled to exercise any jurisdiction, power or authority except the Supreme Court and the High Court exercising jurisdiction under Articles 32, 226, 227 of the Constitution in relation to the matters referred to in sections 4, 5, 6 and 18.
Council, we are very clear that this bar is only with regard to the civil courts entertaining jurisdiction.
Yes, sir.
Because section 9 comes into play.
Absolutely.
All matters civil in dispute can be entitled. But if a particular law excludes the provision of the said court, this is a clear case, no problem.
Your
This
Lordship-
means the power of the High Court or the Supreme Court is not taken away. That is well made in
Your
Article
Lordship,
16.
that was what the council wanted to read. Thank you very much. Your Lordship, moving on to the last leg of the fourth issue. Excessive discretion of the credit information company. Your Lordship, if Chapter 5 of the CIC Act is surveyed by the bench, Chapter 5 restricts the scope of operation of such CICs to regulation and management of credit information. However, in this particular case, it's the contention of the council that the CIC has purported to frame the policy of commercial banks, and this is definitely outside the scope of authority that is given under Chapter 5 of this particular Act. For instance, Your Lordship, the council...
So it has usurped the jurisdiction.
Yes, Your Lordship. Your Lordship, this is a private unlisted company. This is not a regulatory body. This has been authorized to issue directions or frame policy under Section 10.
Chapter 5, please take us to Chapter 5 quickly.
Yes, Your Lordship. Chapter 5 is sections 14 to 18 of the CIC Act. 14 specifically deals with functions of the credit information company. If the bench could refer to such
Yes, page 9.
Your Lordship, functions of a credit information company: to collect, process, and collate information, to provide credit information to its specified users, to provide credit scoring to its specified users, to undertake research projects, to undertake any other form of business which the Reserve Bank may specify by guidelines, by regulations. Your Lordships, it is the contention of the Council here that as per paragraph 14 and 15 of the Moot proposition, the appointment of nodal officer by the bank, who is a bank officer, must be as per the membership criteria of the credit information company. Now, this is the policy of a private company dictating the internal policy of another private company. Therefore, this is not permissible before law, Your Lordship. The Act does not authorize an individual private unlisted company to frame policy. Section 10 authorizes only the Reserve Bank of India to frame policies of the banks. However, in this case, they have gone beyond the scope which is given to them.
Council,
Yes, Your Lordship.
just 2 minutes of time.
Yes, Your Lordship. The Council will be
Legitimize
wrapping.
as far as possible.
Yes, Your Lordship. Therefore, in this particular case, since the influence, the undue influence exerted by the CIC on the commercial bank or through the contracts drafted between the CIC and the commercial bank, such contracts are unconscionable in nature and must not be held valid under the case of Central Inland Waters versus Brojo North Gangoli. Your Lordship, it is also contended that the CIC has refused to disclose information even after requests came from the commercial bank, the bank manager, as well as the one whose right has been agreed. The CIC did not follow the procedure established under section 21 clause 3 of the CIC Act, which mandated that a borrower can approach the credit information company directly in case of rectification of credit information. Apart from that, the CIC is also refusing to give information regarding which department to send the rectification or details of the transaction to. Therefore, in that particular case, the CIC violates the adi alter partem principle of natural justice of not hearing the other side, refusing to hear the other side. And as per the case of Hindustan Steel versus R.N. Banerjee, such cases, especially if there are civil consequences, the principle of natural justice, if violated by a private company, can be punitive, can be punished by the Supreme Court, which was held in this case. Your Lordship, in conclusion, there are widespread, pervasive violation of fundamental rights. The policy of the Federal Reserve Bank of India and the policies of the credit information companies are arbitrary and excessive in nature. The principles of natural justice have been violated and excessive discretion has been exercised by the credit information company. Therefore, the contention here is that these actions must be held to be arbitrary.
We would like to give one more minute time to you. Please amplify the scope of section 21 to the facts of this
Yes,
case.
Your Lordship, gladly.
Article 21 of the Constitution. Because life, liberty, how is it involved?
Your Lordship, my co-counsel will be dealing under
No
issue 3
problem, no problem.
with regards to data privacy.
What? Fine.
Council will be dealing with the right to privacy guaranteed under Article 21. How it is being violated.
Fine.
Therefore, the Council contends that the directions of the RBI and the policy of the CIC are arbitrary in nature, and the Council submits his arguments and considers it a deep and great obligation or great honor to have argued before this commission.
Do you want to rely upon the provisions of the Right to Information Act also here?
My counsel will be dealing with.
Will you deal with that?
He'll deal with the right of privacy, Your Worship, data privacy.
Incidentally, if right to information is also required, he would deal.
Yes, Your Worship.
Okay, fine.
Deeply obliged, Your Worship.
From him, you will have to supplement it.
Council is well aware of.
Fine.
Permission to address the bench as my
Agree, sir. It will be remarked, yes.
permission to permission to address the bench as a whole is my lord.
Yes.
This council number 2 will be appearing on behalf of the petitioners in the present case, and the council 2 will be dealing with issue number 2 and 3 respectively. Issue number 2 pertains to whether or not the creditworthiness of the different stakeholders has been taken into consideration and whether it has been adjudged correctly. With the leave of this honorable court, the council would like to proceed towards the arguments of the present case, of the present issue at hand. Much obliged, my lord. This Honorable Court in a plethora of judgments has expounded the scope of Article 14. Article 14, which talks about the right to equality, has been effectively expounded in the case of State of West Bengal, which is Anwar Ali Khan, where the court has held that the equality before law and equal protection of law are natural consequences of each other, and while they both have different meanings, they need to be interrelated. They need to be read synonymously. Under the right to equality, if any classification is to be made, it needs to be in nature of permissible classification and reasonable classification. For criteria for any reasonable classification is that it should not be arbitrary, evasive, and artificial in nature. Furthermore, the classification should also be based, importantly, and to be highlighted, on an intelligible differential. This differential has been applied in the classification. It should have some real and important connection with the objective which is sought to be achieved by the classification. As it has been held in various judgments by this Honorable Court in V.S. Nakara versus Union of India, Air India versus Nagesh Mirza, the scope of Article 14 is quite important and it needs to be considered with heavy importance in this present case. The council would just...
on a lighter note, see, this court will have laid down some law on a particular point. So that is the exact point where a law is laid down. Subsequently in decisions, they might have been followed. You can only say reiterated. The law laid down by this court is reiterated in these decisions. Every time law will not be laid down on all aspects. There may be a little, say, some few words adding or subtracting, that's all. But the principle enunciated in one of these decisions will be the law and that will be followed. If not followed, they will have their own course. So please just keep in mind. This is not for the purpose of the facts of this case. I can only say you are a young counsel. You need to know this nuance.
The council will not repeat the same mistake.
No problem, not a mistake. These things happen in court. It's our duty to see that the young counsel learn well.
Much obliged, my lord. My lord, I would just like to briefly state the facts of this particular issue before, just to refresh the mind of the bench. Is it, by leaving this court, may I proceed to...
Yes, yes.
So in this case, the petitioner, Mr. Ramasamy, being an NRI resident, has applied for a loan of 12 lakh rupees. However, when he submitted all the relevant documents for sanctioning of the loan, all the documents which included page number 2 of the...
We have the list, don't worry.
Which included PAN card, Aadhaar card, also his income tax returns, filing of his income tax returns are all submitted.
All required documents.
All the required documents are submitted. The banker was also ready to give the loan. However, when the creditworthiness of the individual was to be considered, it was a shock to the petitioner that this creditworthiness has been adjusted as -1, as -1. And it was also followed by a negative connotation saying that this creditworthiness is lack of creditworthiness, meaning that he has no capacity to pay any sort of credit which has been borrowed from any credit institution. My lord, my humble submission is that the reason why my petitioner has been adjusted as -1 was not because he was an NRI, was not because he failed in submitting any of the relevant documents, but solely because he hasn't taken a single credit loan from the country. And that is the reason the credit institution companies have ranked his creditworthiness as -1 and followed by a negative connotation of lack of creditworthiness. My lord, the second fold of I would be substantiating the whole of the argument through a four-fold argument. This is the second fold. The third fold of the argument is that the objective of the Credit Information Companies Act. The very objective of this act was to make sure that the credit institution, before disbursement of the credit, is able to check the veracity, is able to check the capacity of the borrower so as to avoid
Say unpleasant things.
as to avoid any sort of
Default
any sort of a default in the near future, and his credit worthiness, as is mentioned in under section 2 clause D under credit information. the creditworthiness comes under the purview of credit information and is also mentioned under 2 clause G, which is page number 4 of the Act. Credit under the ambit of credit scoring means a system which enables a credit institution to assess the creditworthiness of and capacity of a borrower to repay his loan and advances and discharge his other obligation in respect to the credit facility availed or availed by him.
So the benchmark fixed by the credit rating institution that he or she should have credit scoring, he or she should have availed prior loan itself is a bad benchmark, and it is in violation of the definition of credit scoring under section 2G. That's what you import to, what you focus
That is one of the submissions that the council is trying to make. So main objective was to make sure that the borrower is in his full capacity to repay back his loan, and so that he doesn't regularly default. If in the event that he's defaulting the loan, his credit score will come down, is what the council is submitting. However, in India, in our country, the credit institutions work apparently differently, because when a borrower's account has been turned as an NPA, or when the borrower is not able to repay back the loan, his credit score will not be -1. It will be in the range of 200 to 300. However, it will not be in the -1 range. This is what the council is trying to state again and again, is because the person whose lending capacity has been reduced, who does not have any kind of lending capacity, has been adjusted on a different level. However, a person who has not taken a loan at all in his life has been given on a different footing, where the main objective of the Act is to make sure that the person who is able to repay the loan is being given a credit. However, in this case, the person whose account has been declared as NPA, a person who does not even have a job but has an account, or a person who is not even able to repay back the loan. Certain lacunas like these exist, and still the credit information companies value their credit score in the range of 200 to 300, even though it may not be possible for them to get a loan at a very low interest up to their specifications. It is still possible for them to get any type of loan. However, in the present case, the petitioners do not have the same footing. It is given as -1, and it was not only.
Therefore, please read the object and reason, which is spelled very quickly, very short. An act, first page, an act to provide for regulation of credit information companies and to facilitate efficient distribution of credit and for matters connected therewith or incidental thereto. The purpose for which the act has been brought into force is found here. You have to focus on this, and all others flow from that object. Yes,
proceed, my lord. However, the council will also cite section 14 of the Act, which says that a credit, which elucidates the functions of the credit information company. And clause A, B, C is what the council is relying on to collect, process and collate information on trade, credit and financial standing of the borrowers of the credit institution which is a member of the credit information company. B, to provide credit information to its specified users or to the specified users of any other credit information company or to any other credit information company being its member. And C, to provide credit scoring to its specified users or specified users of any other credit information company or to other credit information companies being its members. So that exists an obligation under section 14, also under section 21 of the Act, which talks about the veracity of the information that needs to be given by each and every credit information company to the credit institution, and there cannot be any sort of an ambiguity, any sort of an discrepancies while giving the information, which the credit information companies have effectively evaded to do so. My lord, my humble submission.
Yes.
My lord, my humble submission is that the creditworthiness of this petitioner, however, the petitioner has set aside his claims and he is no longer pursuing his loan. However, the petitioner, being in a public-spirited person, is representing the marginalized sector of people in this country, where the people who are applying the loan for the very first time, their credit score will naturally be -1 and will also be followed by a negative connotation of lack of credit worthiness. Irrespective of whether or not they have a stable income, whether or not they have a collateral, or whether or not they'll be in a repayment capacity, it will still be -1. And there is a lacuna which the credit information companies have not specified through the Reserve Bank of India, nor the credit information companies has specified in their policies that the credit worthiness of a new individual for to be taken into account should be adjudged separately to those who have been lagging or those who have been not paying the credit loans, and it should not be in the same footing. If the council is not having any other further question, the council will move to the third issue at hand, the last issue at hand. The internal policies followed by the credit information company, the collection of information and data privacy are violative of any fundamental right. My lord, I would like to humbly state the 9th bench judgment of Justice Puttaswamy versus Union of India, where it has been established by this honorable court that the right to privacy, as enshrined in Article 21 of the Constitution, is not absolute in nature, which the council also, however, the right to privacy is to be subject to satisfaction of certain tests and benchmarks, and a person's privacy interest can only be overridden by competing state and individual interest. Furthermore, the council would like to state the submission of the judgment wherein Dr. D.Y. Chandrachud of this honorable court has said that the inviolable nature of the human personality is manifested in the ability to make decisions on matters which is intimate to human life.
Don't say refer to the name of the judge. It's a constitution bench judgment. It's a collective decision of the court. Just refer to the case.
The council takes notice of the.
Yes.
The council would like to briefly brush up.
How do you justify that the data received from you is passed on to others and thereby violated, and as such Article 21 is violated?
The council will be coming to it.
Yes. I think that's the core issue, in this.
That is the core issue, indeed, my lord. The council would like to just brush up with the other facts of the present issue, if it is possible.
Yes.
The other petitioner is Miss Pallavi Mistry, who had already obtained a loan for her car. However, her credit score, when she has been repaying back her loan, the banker, because of his negligence, the repayment was wrongly calculated, which resulted in her wrongly calculated. So hence, when Miss Pallavi Mistry wanted to inquire what her credit score was, it drastically, upon the inquiry being made by Miss Pallavi, her credit score went down from 799 to 595, as mentioned in under paragraph 14 of the Moot problem. My lord, I would like to state that there are two types of inquiries with respect to credit scoring. One is a hard inquiry. That is when a person applies for a loan and a respective bank checks up the person's repayment capacity, checks up the person's credit score. That is known as a hard inquiry. Whereas a soft inquiry is when a person who applies, the person himself is applying for a loan, and the person himself is checking for the credit score and what his or her credit score might be. That is known as a soft inquiry. It is submitted that both the hard and soft inquiries result in deterioration of credit scores. However, it has been into a drastic nature where it has dropped from 799 to 595, a total approximately of 200 points. The point which I am coming to is, my lordship, that the internal policy of the credit information companies dictate that upon it is a discretion of the credit information company to deteriorate the credit score however it likes. This is because, and the respondents take a stand.
Mr. Counsel, so if that is the issue, so it is coming within the purview of deficiency of service. You can approach the consumer forum. No, if they are, that is giving. that type of information according to their whims and fancies.
The council,
No, it comes under the deficiency of service.
the council would like to state that since there has been a fundamental right violation and since the petitioner has approached Article 32 of the Constitution,
No, it
even
is
if
a
there's-
mistake committed by the bank. It is not in respect of all the creditors. It's an individual case. So then under such circumstances that the individual can approach the consumer forum, and there also the provisions are there.
However, my lord, in this particular case, even when the petitioner raised a grievance, that when the petitioner raised a grievance with respect to the credit score, the credit information company did not disclose it in full. They did not even consider to.
So as my brother judge has already informed, that the right to information is there. So you can apply. Right to information, you will get all the information.
I understand the.
So if they without any information, so you are having that is a specific act. So under that particular act, if you file an application with prescribed fees, so they are bound to give it within 7 days.
Over here, my lord, the mistake is not the mistake on part of the bank is not a problem in this particular case. It is the updation of the credit information score that is a problem.
It is a clerical mistake.
It is a clerical mistake, which the council is not taking into purview in this present issue, my lord. The council is more into the system or the functioning of the credit information companies as well as the contracts which they enter into between the consumers and
No, that's why I am saying it is an individual aspect. So you cannot take it as a public issue. It is in respect of that particular individual case.
My lord, what the council would like to contend is that this case is not stricto sensu individual. Ms. Pallavi Mistry is fighting on behalf of the.
So whether you have produced any such instances except that Pallavi? No. Before this court, no other such instances are produced. You have not made any research on that.
My lord, in the Moot proposition.
Yeah, that's what Moot proposition is only in respect of that Pallavi. It is not going to say anything with regarding to others. So if any information is there that in many such cases that it has happened, so these are justified.
It is the humble contention of the.
Okay, the endeavor of the court is to know. You could have applied under the provisions of the Right to Information Act, but such an attempt was made. That's all. We are not coming in the line of your thought. Just say we wanted to know whether any effort was made. Otherwise, as you said, Article 32 has a very large sweep. You consider all aspects. Even if one party appears with single incident, and if reasonable inferences can be drawn that statutory authorities have not done their duty, we are here to step in.
I understand, my lord. Even as envisaged under Section 8, Clause 1, Clause J of the Right to Information Act, disclosure can be made if larger public interest is satisfied, my lord. However, in the present case at hand, the council would like to draw again back to the Puttasamy judgment where the meaning of consent is being, the scope of the meaning of the consent is being expounded in this bench. The council will just take 2 minutes of the time with the leave of this bench, if it's possible. In this, it was held that the consent so obtained for a processing of the personal information should be free, informed, specific, clear, and very importantly highlighted that the consent should be capable of being withdrawn and held, and while holding such statements, it held the Aadhaar Act to be a valid act. However, in this case, the consent has not been obtained stricto sensu, my lord. If my lordship could refer to the notification given by RBI. One second, my lord.
Page 74, 73 of the complaint. This one, this here, page 73. So are you referring to circular?
No, my lord, no, my lord. I'm not able to.
Are you referring to paragraph, page 71, annexure 1?
No, my lord, it's different.
Okay, anyhow, we will use time. Please go ahead with the other issues.
Where the Reserve Bank of India has made the consent clause in the credit information companies as redundant, meaning that it will be ineffective, meaning that if the consumer gives his consent or not, his credit information will be processed, his credit information can be accessed, and his financial credit information can be withheld by the credit information companies, and only upon payment of fees shall the credit information company disperse his credit score. So such a clause is unconscionable in nature, and and referring to Central Inland Waters case, where the court has held that section 23 of the Indian Contract Act, where it is opposed to public policy, such a contract needs to be struck down as void. And the council would like to rest the submissions and would like to move on to the prayer of the present case. Therefore, in the light of the facts stated, issues raised, arguments advanced and authorities cited, it is humbly prayed that this Honourable Court may be pleased to hold, adjudge and declare that the present writ petition is maintainable. B. The creditworthiness should not be the sole criteria for disbursement of loan. C. The guidelines to be framed by this Honourable Court for effective data protection and data principles. And D. The present credit score policy of the FRBI is not permissible under law and requires the body to frame more specific guidelines and pass any other order as it may deem fit in the interest of natural justice, equity and good conscience, all of which is humbly prayed before this Honourable Court.
You have forgotten to highlight one important aspect. See, both the bank and section 21 subclass 3 at page 12 of the Act, please see, both of them have the responsibility. Either of them will have to do.
We can request any one of them or jointly.
Jointly.
That is the
But
also
burden
section
is upon them. Subsection
21,
3 of
21
section
says.
21. If a credit information company or specified user or credit institution in possession or control of the credit information has not updated this information maintained by it, a borrower or client may request all or any of them to update the information, whether by making an appropriate correction or addition or otherwise. And on such request, the credit information company or the specified user of the credit institution, as the case may be, shall take appropriate steps. It's a very important provision. You have forgotten to highlight
And the
this.
presentation has been made by Ms. Palay Mystery, which has been discussed by my
Fine.
counsel.
Thank you, Counsel.
It has indeed been an honor arguing before this honourable bench.
It's also a privilege for all of us to see young lawyers coming and arguing before the top court. Thank you.
The council seeks permission to order lordships as lordships and the bench collectively as your lordships. Much obliged lordship. If the lordships are well versed with the facts, the council seeks permission to proceed with the issues directly.
Tell us in a nutshell, we would like to know how you present it.
Much obliged lordship. The petitioner, Mr. Venkatesh Ramasamy, whose report taken suo motu by this honourable court, is a first-time borrower whose loan application is rejected, citing that lack of credit worthiness, and based on his rejection, he made a report and submitted to the Honourable Chief Justice of this court to highlighting that the inherent flaws of credit data analytics model of CICs and also the inadequate application of privacy principles laid down in Justice case, Puttaswamy case, which is violative Article 14.
By whom? By whom? Inadequate application of the principles enunciated in Puttaswamy's case. By which institution? Whether it's a institution or a bank. Who has violated?
Who has violated that?
Much of the lordship. In the case of Justice Puttaswamy, it is up to the UDAI.
No, you said now there is a violation of that judgment
In this
principle
case.
stated in this case. Who has violated that? What is the provision? What is violated here?
Indeed, Lordship.
How it is applicable
Which
here?
institution has violated the principles enunciated in Justice Purpose Law?
Yes.
Which institution is in present case?
Indeed, Lordship.
Right, for this. Yes.
Indeed, Lordship, it is on the report it is highlight credit information companies were alleged that they violate right to privacy.
Oh,
Yes.
fine.
Much of it, Lordship. The council seeks permission to present first two issues, which is pertains to the constitutional questions of these highlighted issues by the report, and the third issue, which is only which pertains to the technicalities of credit information data analytics model, which is dealt with my co-counsel. Much obliged, Lordship. From the first sub-issue, that is the contention of the respondent that this petition is filed under Article 32. It is signed to or not to show that if the petition filed under Article and seek relief under that, it is signed to or not to show there is a violation of fundamental rights, and that violation must be done by the state, which is defined under Article 12 or the instrumentalities of the state. Our contention is this instant petition lacks the essentials given or specified in Article 32. That is, firstly, as per the contention of our learned counsels, that is, the respondent is credit information companies, which the four companies or license given certificate by RBI. These credit information companies are for the sake of argument are the not instrumentalities of the state. It is contention of the respondent that CICs are non-statutory bodies. The non-statutory bodies or whether these bodies are state or not, it is decided by the.
No, sir. It's a statutory body. It is a creature of a statute called Credit Information Companies Regulation Act 2005. Whether it is a state within the purview of Article 12 of the Constitution, you can highlight. It's a debatable question, but it's a statutory company. It's a creation of a statute.
Much of the Lordship, indeed not Lordship. I kindly draw your attention to the fact number 1 that is clearly stated. Metafacts Data Analysis India shown the facts, Lordship.
Yes.
Point number 1. It is a public unlisted company incorporated on 26 June under Companies Act.
Yes.
It is just have the place of operation, which is only certified under CIC Act. So it is a non-statutory body. It is a long been decided by this honorable court that in the case of Pradeep Kumar Biswa's case, which laid down a decisive test, that is whether a non-statutory body or a organization is state or not, to enforce writs under Article 32. It is a test that it is more emphasis on function and control test. It is a function test that it is relevant to the share capital held by the government. In this fact, no one mentioned that not less than 51% of shares is held by the government. Even it is also a public unlisted company too. So, and secondly, the control of the state, which is the control of the state actors, must be pervasive in the functions of such body. It is contention that under credit information companies, the Reserve Bank of India has only to direct policies under Section 10 and give directions. It is mere regulatory control of Reserve Bank of India, and it cannot be deemed CICs as a state which operates in the business of data analytics and technology. So it is our humble contention that CICs are not state or instrumentalities of the state. Hence no writ, and hence it is not amenable to issue writs against it. And the second contention of the council is there is no violation. Its contention is there is no violation of Article 14 and Article 21. It is Article 14 in preview of Article 14. If there is a breach of Article 14, it must be shows that there is an arbitrariness associated with that action of the state. In this instance, credit information report or credit information system, it is adopted and implemented in India by various committee reports. Council kindly draws your attention to the fact point 4 of the fact, where it is stated several committee reports in India and overseas, including that of World Bank, suggested that credit information is very essential to lend fairly, consistently, responsibly, and more importantly to prevent frauds. It is of public interest, Lordship. and it is stated since it is adopted by with strong scientific and statistical proven facts that credit information is essential to control the rise of non-performing assets, which will affect adversely the Indian economy. It must be adopted. Hence, the implementation of credit information system in India is not arbitrary. Hence, it is not violative of Article 14 of Lordship.
But what they concern for the other side has lately is the manner in which the credit informations received from the concerned users. They have not been properly used and they have been misused, So there are several instances, and therefore a public interest litigation petition is filed representing similar large number of farmers.
Much of the Lordship, there is no classification that may disadvantage these larger section of farmers. If the farmer, there can be three types of farmers, which is the first who got loan and maintain his financial discipline. Second is the default faulters. Third is the first time borrowers. And these farmers do not have, if any reasonable classification is made, it must be show the yardstick which grounds these classifications should be made. And there is no such ground to made reasonably is there. Hence, the uniform application of credit information reports to all the sections is not violative of Article 14. And also, Lordship, the question pertains to the misuse and the technical natures of data obtainment and use and share will be dealt with my co-counsel in the subsequent issues. And much obliged, Lordship.
Yeah,
Much obliged.
here, the criteria that they have used. So he's admittedly NRI, he's having sufficient income, and he's a first time borrower, he applied. And persons who committed default and who are having NPA accounts, and you give some score. That's what is argued by the other side. And for the first time borrower and who is having salary, everything he has produced. And see, he has gone through the case, and his family was suffering from COVID, and in fact they died. He wanted to buy a car, and it was not provided. It is a violation of a right to live. He lost his family because of not getting loan. And what is the criteria? This person, when he is having produced all the documents, and he is having income also, he has produced, and you assess him, he is not creditworthy. What is the criteria?
Those default persons who commit default will come within the range of 200.
So 200.
A
And
man
this
who had never raised loan from any bank or any non-banking financial institution, and whose financial background was clean. Now he is -1.
What is this difference in
The
the
manner in
Article
which
14?
the case is applied.
That's what the other side argued. For Article 14, there must be some guidelines, some intelligible difference here. What is here? What is the basis for this?
Much obliged, Lordship. Credit score, which is meant to decide credit worthiness of an individual, it is clearly limited to the criteria that it is credit worthiness of individual.
Yes.
Firstly, the credit worthiness can be only determined for a person who got credit.
Yes.
Lordship, and it is not to cover entirely the repayment capacity of the individual. Lordship, it is only the credit worthiness. If it is only applies that, I can kindly refer this quote to the point number 13 of the fact, which states that even a person without credit score or even a poor credit score can avail loan, but the interest rate will be higher for him who don't have a sound credit score. It is to the risk of the banker who believes in him and takes such risk to provide him the opportunity of availing loan.
Does it not amount to discrimination between the first time loan seeker and the person who has already availed a loan?
Much obliged, Lordship. The loan which was provided by the private banks, and we cannot compel private banks to lend their own money if they have a liability to pay towards RBI and their employees, and it is a profit motive company, and we cannot we cannot compel them to do the welfare actions of the state.
No, whether rate of interest are governed by Any RBI or any whims and fancy, anybody can charge any rate of interest for one person this interest, for that person this interest, or default of this interest first time this interest. Whether such thing is permissible?
Much obliged, Lordship. As per the rules of RBI, there is a range of interest is prescribed, that is minimum interest rate and maximum interest rate. It is a range, and the bankers only can sort the interest rate under this range. They can provide credit worthiness. There is a chance of paying the amount easier. Then they show, then they lend them with low, and if the chance is low, they lend them high. And it is not exorbitant, Lordship. It states that it is high credit score, but it is not exorbitant, which is forbidden by law. Hence, no violation of Article. And Lordship, the second issue of this, Lordship, that is the legislations governing credit information companies is lax or inadequately applied with the principles laid down under K.S. Kudaswamy case. That is, in this case, with the some of the contentions that there is like, if what are the circumstances can the right to privacy arbitrarily intruded by the state or a non-state actors too. It is stated that if the information sought it is not proportional to the object, then it will be the violation of Article 21, which is privacy. And secondly, the nine principles given by Sri Krishna Committee in the same judgment, if these principles are not followed by the collecting agencies or a body, then it will be the violation of Article 21. And
that data privacy bill is yet to come. Justice Sri Krishna Committee's report is before the Supreme Court and it's before the Parliament, and it is now referred to the Select Committee. It is yet to take the shape of a legislation. We will see what would be the only so far as some deviation in the right to privacy cases in Aadhaar. That's all. Some leniency is given to right of privacy only with certain riders. That's the 5-bench decision in subsequent cases.
Indeed, Lordship. Council is trying to make the point that the legislations which is adequately, the legislations that are Credit Information Companies Regulation Act 2005 and the statutory rules derived under Section 36 of the same Act, which is 2011, is adequately applied the principles, the two essential pillars of the judgment. That is, Your Lordship, in question of inadequate application raised by the learned counsel, that is, it is inadequately applied the 9 principles of which is laid down case Kudaswamy case. It is the contention of the counsel that these 9 principles laid down in the case Kudaswamy case is adequately applied with technical knowledges. That is what in recent rules of CIC Regulation Act 2011, which is given to the Your Lordships. That is, the first principle is disclosure. In CIC Regulation 2006 9.5.1, which is stated that the credit information will not be disclosed to anyone unless the order of court or the such specified user made. And secondly, that is pertains to security. It mentioned that 9.2.2 Credit Information Companies Regulation 2006 states confidentiality. All employees of credit information companies must take suitable declaration of fidelity and secrecy. And also the important principle is that issuance of notice, if any issuance of notice which is set in Section 16 Clause A, where the notice will be served to a concerned individual, and if this concerned individual rejects such notice, no credit information of the individual will be given to the other third parties. And it is also mentioned that there is a clause of liability and penalty, which is a 9th most important principle. That is, Section 18 of CIC Regulation Act states, if the breach of data has happened, the such credit information company is liable, and they must amenable to give remedies for the aggrieved parties, which is aggrieved parties, and all the other 9 principles, such as other principles, accountability, openness, also detailing complied by these chapter 4 of privacy principles sections, Your Lordship, and that there is adequate application of recent case Puttaswamy judgment in the legislations governing CIC's Lordship. Your Lordship, Council humbly hereby concludes its argument that the public in this writ petition is taken as home rule. It's a public interest litigation, lacks public interest, as these are the arguments or the contention made by the learned counsel are only addressing the concerns of Mr. Venkatesh Ramasamy and Ms. or Mrs. Advocate Mr. Pallavi. And as public interest litigation is an essential tool to bring out justice for the person or a deprived person who can't reach the doors of the court, but being an advocate, she can't reach the doors of the court, and this public interest litigation deals with the matter of the concerned, which has other alternate remedies under the adequate remedies under the Act, is lacks public interest, and concludes that there is no violation of Article 14, Article 21, and the CIC is included as a respondent, is not a state, and it is not amenable to writ jurisdiction, and the subsequent issue will be dealt with by co-counsel.
Hope you have read section 20 of the CIC Act, which deals with privacy principles. Are you sure? Because this is an act of 2005, long prior to the judgment in case Puttaswamy's case. Are you sure that the principles laid down in section 20 are in parity with the principles laid down by the Honorable Apex Court Constitutional Bench decision in Puttaswamy's case?
As I mentioned before, these 9 principles were the result of Sri Krishna Committee's report, which is taken in 2005 itself, and this act comes in 2006, and with the 1 year gap, it adopts all the principles to be compliant with the CIC's legislation, Your Lordship. Your Lordship.
Thank you, Counsel.
Appearing on behalf of the RTA and credit information companies, and dealing with the third issue, whether there are inherent flaws with respect to the data analytics model of the credit information companies, with respect to its application on the first-time borrowers, with respect to its results, and with respect to its fulfillment of its object, and with respect to the procedural complications in getting the credit score updated. Lordship is humbly submitted that the credit information companies are with the object of enabling a fair, consistent and responsible lending environment, thereby preventing fraud in the financial markets and increasing the capital flow, cash flow and the liquidity in the markets. So when preparing the credit scores and credit reports to give it to the banks and financial institutions, we also immensely contribute to the financial health of this nation. Lordship is humbly submitted that the credit information companies utilizes the credit repayment history, the credit balance and utilization, and the data regarding the nature and the utilization, nature and the duration of the loans which were abided by the borrowers. Since the first-time borrowers have no such credit history, consequently, it produces the credit scores in minus. Lordship is humbly submitted that credit score in the minus does not inherently mean that a person is of lack of creditworthiness. Lordship is humbly submitted that the credit.
Is it anywhere spelled out so unequivocally in the act? Because the apprehension is that I have been rated as -1. What does it mean?
Your Lordship, the poor credit score, the credit score system itself starts from the creditworthiness. Its system itself starts with credit score of 200.
No, is a first time borrower.
Yeah, yes, Your Lordship.
What is the criteria for them?
Your Lordship.
You have not borrowed any loan, no, anywhere, anytime. The first time applying, what is the criteria for that? How will the
Your Lordship's criteria for the disbursement of the loan, or with respect to the credit data analytics of
no, how you rate is credit score?
Your Lordship's
Ultimately, the disbursement of loan is based upon your report. What benchmarks you apply and what result you give, the financial institutions will follow.
Your Lordship has humbly submitted that it is misconstrued that the credit scores are a conclusive factor for the disbursement of a loan. It's humbly submitted that when a credit score is either low or for the first time borrowers, the banks and financial institution, regardless of their credit scores being -1, the banks and financial institution uses certain alternative data such as financial etiquette or the financial stability of the individual or else the data regarding the utility and bill payment history and the spending and the consumption behavior of the first time borrowers. Since these are the data regarding the financial management habits of the first time borrowers, these data are not available with the credit information companies. The credit information companies can have only the data regarding the credit repayment history. These data are regarding the financial management habits. These data will be there only with the borrower, and then the borrower give this data to the lender or the finance institution, and then regardless of the credit score being -1 or poor, the banking and financial institution will only decide whether a loan can be disbursed. Your Lordships, if your Lordships may kindly look at the facts.
Facts here only on the basis of that is a credit score, that this application has been rejected.
Your Lordship, this very fact that this is not actually the case of Mr. Venkatesh Ramasamy, because if your Lordships may kindly look into paragraph 17 of the facts, Mr. Ramasamy decided to forego the loan application, but decided to submit the findings of his report with a marked copy to the CM, PM's office, Finance, Ministry of Finance, and the Government of India and the Federal Reserve Bank of India. So he has already foregone his application. And then only he is filing the report stating all the inherent flaws, researching on all the elements. So this particular case is not the case of Mr. Venkatesh Ramasamy. Neither he has a right in person in. This is the case where invocation of a right in rem, as my learned counsel stated it to be a public interest litigation. So therefore, it cannot here. This is not like a forum to discuss where what could have been the possible reason if it is not that he was the first time borrower, why he was not disbursed of a loan. But in Lordships, in reality, even if a person is with being a first time creditor, if his financial etiquette is so well that he has discipline and good financial management habits, then the bank and the financial institution may consider his loan application. Lordships humbly submitted that.
What is in respect of farmers? Because this so much of public interest litigation is raised, including the individuals, also with regard to farmers. What should be the criteria, whether there is any specific guidelines for assessing the credit score of these farmers?
Such issues are also raised.
Your Lordships, it may be noted that in this particular issue, there are three types of farmers. One is those farmers who have who have not repaid the loans. So their scores being poor scores. And second sort of farmers are those farmers who defaulted in the last preceding years, but their loans were waived by the government of Karnataka. And the third sort of farmers are those who are the first time borrowers who were financially independent before. Lordship has humbly submitted that the first two borrowers, for the first time, for the first sort of borrowers, that is those who have really defaulted the payment, the credit score will be poor. And for the second, those whose loans were waived will not be considered. The waiver of the loan by the government of one state shall not be considered for calculating the credit worthiness of an individual, because that does not have a nexus with the object of the credit information procurement. Because tomorrow, when such a waiver is made and then the waiver is considered for computing the credit history, and if a person is given a loan, and in case if such a waiver is not happening in the future, obviously the system will be in entire flaw. And third thing is, your Lordships, which clearly shows that the third farmers for the first time borrowers are not rejected of the loan. They are imposed of a differential rate of the interest. The Lordships humbly submitted that the opposite parties have contended that it is a violation of Article 14 to impose a differential rate or to reject a loan on the basis of a violation of Article 14. The Lordships humbly submitted that there are two clauses. One is a clause with respect to first-time borrowers. And another one is a class with respect to a person who was having a poor credit score or an ideal or otherwise an ideal credit score. Because if somebody submitted no stretch of imagination, a person with a ideal credit score can be compared with a first-time borrower, and therefore this class, Your Lordships, as it was held in the case of state of West Bengal similarly, the Article 14 does not prohibit classification. It only prohibits class legislation. So there has to be a rational nexus between the object of why the classification is made and why the objects of the provisions of the Act. Lordships humbly submitted since the object of the credit information company is to enable a fair, consistent, responsible environment. Distinction between differential interest payment for a first-time borrower with a first-time borrower and a person who has availed the loan and have shown a good financial discipline through continuous content of the payments is inherently not a violation of Article 14 of the Lordships.
Okay.
Lordships,
Proceed.
Lordships humbly submitted that the RBI has only mandated the procurement of the credit scores of the borrowers to ensure that the lending decisions are taken by the banking and financial institutions which are backed by the available system. Nowhere statutorily the Federal Reserve Bank of India mandated the credit scores of the borrowers must be high for the disbursement of a loan. So it is only the banks and financial institutions who are taking a decision with respect to disbursement of a loan. Lordships humbly submitted that the CMCs were not permitted to take direct lending decisions. They provide only the credit scores, which is then used as a basis to either reject or accept a credit application, but that depends upon the banks and financial institution Lordships. In case of the banks and financial institution thinks that in the raising non-performing assets, they should give the loans only to the person with good credit score and not to the first-time borrower. It is left at their discretion Lordships, which shall not be questioned by the Federal Reserve Bank of India. We are not authorized to question that Lordships.
The council was this whole object of the Act is an Act to provide for regulation of credit information companies and to facilitate efficient distribution of credit and for matters connected therewith or incidental thereto. If he wants to avail credit from a bank or a financial institution, this the information provided by an entity under this Act is the relevant Act. Therefore, you can't say that the bank can have apply their own other methods even if -1 is noted. I think you will have to be very careful while applying that.
Yes, Your Lordships. However, this particular application is conforms to the object Lordship. That is the differentiation of the interest rates of the first-time borrower or the other borrowers who have shown good financial discipline and those who have got a good credit scores, and this difference under Article 14 conforms to the object of the CACR. That is how it not violates Article 14. Your Lordships humbly submitted that the next contention of the Council is whether there are inherent flaws with respect to results and non-fulfillment of the objects of the credit information companies. Your Lordship humbly submitted that the economic data of the Federal Reserve Bank of India has shown that the credit information companies has played a vital role in reducing the non-performing assets. Your Lordships, it's humbly submitted that in the financial year 2014, in the financial year 2004, the gross non-performing assets in our country was 7.2%, and the CICRA enactment came in the year 2005, and the rules were notified in the year 2006. In the very next year, in the financial year 2006, the non-performing assets was contracted to 3.3%, and this contraction was so constant that in the financial year 2012, it again contracted to 2.5%. So, the very impact is also contained in the RBI data suggests that this suggests the importance of the credit information company in reducing the non-performing assets of the company or the non-performing assets of the country.
Have you furnished an information to the effect received from the RBI?
Yes,
is it a part of your arguments notes?
Your Lordship,
I think you provide that also.
Yes, Your Lordship.
If you want to make it as a
this is the table with respect to the gross non-performing assets reduced, Your Lordships, from the financial year 2006, and this is a data which has been endorsed by the Deputy Governor of the RBI, Your Lordships. Your Lordship is humbly submitted that there is another report which suggests that the total non-performing, nearly 60% of the total non-performing assets in the year 2018 was contributed by unrated borrowers, that is the borrowers whose credit rates were not rated. It clearly shows how the importance of the credit rating with respect to lending, fair, responsible, and consistent lending to lordships. And the report is before your lordships, which suggests that the 60% of total non-performing assets are contributed by the unrated borrowers, and this report is downloaded from the website of the official website of the RBI. The lordships humbly submitted that the object of the CIC is to enable a fair, consistent, responsible lending environment. This object is not defeated by the commercial subscription model which is being made by the credit information companies. Lordships humbly submitted that as per the credit information companies rules in the RBI notification, the maximum charge which can be imposed for obtaining credit information by an individual is 100 rupees. And this was fixed in the year 2006 through the 2006 notification. Your Lordship is humbly submitted that the credit, that the subscription model is charged at 500 rupees, and then for the other subscribed users, for companies it is more. The Lordship for individual is 100 rupees as per the statutory mandate, and the commercial subscription model is 500 rupees. The Lordship humbly submitted that in the commercial subscription model there will be regular updates. So a person who needs regular updates of the credit scores for any purpose, if he had utilized if he had not utilized this commercial subscription model, and if he had gone for paying the maximum amount which is being notified by the RBI rules, then he will suffer loss as when compared to utilization of this commercial subscription model, and therefore there is no non-relevance, so there is no defeat of object of the credit information company through this commercial subscription model. Your Lordships. Your Lordships humbly submitted that the petitioners have contended that credit scores of Ms. Mystery was depleted from 700 to 500 because of the multiple inquiries. Your Lordships humbly submitted that was not due to multiple inquiries, it was due to the technical errors which were committed by the banks in adjusting the payment amounts and in computing the interest components, and the bank while conveying the repayment history to the credit information company cited the technical error as an overdue delay by Ms. Mystery. So consequently there was an error by the bank made. Your Lordships. Your Lordships humbly submitted that the new credit reports do not directly negatively impact on the credit score. Lordships. There are two types of the credit inquiry. One is the hard inquiry and another is the soft inquiry. Soft inquiry is when a person is making an inquiry to know his credit scores. That is an inquiry which will not result in any subsequent lending decisions. Whereas hard inquiry is an inquiry which will result in a making of a subsequent lending decision. Basically, when already an application already a loan has been pending, and a person is again making an application for a loan, again trying to avail a credit card, the lender will again make a application or request for a credit information from the credit information company. So this shows that the person has a very high risk profile. He is very credit hungry. So automatically, as an impact, the credit scores also get depleted, which is justifiable, Your Lordships. Otherwise, the soft inquiries are not considered. Soft inquiries, that is, inquiry made to know what it is not will not negatively impact the credit scores, Your Lordships. Your Lordships is humbly submitted that my learned friends appearing on behalf of the petitioners contended about the technical issues with respect to the getting the credit score updated. Lordships humbly submitted that in the case of Ms. Mystery, as I said before, there was a technical error by the bank made, and the bank Ms. Mystery had requested the credit information company to rectify the credit score. However, the resolution was promised within 30 days, and then later, later the credit information companies maintained that there was no information from the bank's lordships. The Lordships may kindly look into section 21, Your Lordships. Section 21 of the Credit Information Company Regulation Act, alteration of the credit information files and credit report. Council takes permission to read the provision, Your Lordships. Any person who applies for a grant or sanction of credit facility from any credit institution may request to such institution to furnish him a copy of the credit information obtained by institution from the credit information company. Every credit institution shall, on receipt of request under subsection 1, furnish to persons referred to in subsection a copy of credit information subject to payment of the charges as may be specified by the regulation by RBI. If the credit information company has a specified user or credit institution in possession and control of the credit information has not updated information maintained by it, a borrower or client may request all or any of them to update the information, whether by making an appropriate correction or addition or otherwise, and on such request the credit information company or specified user or the credit institution, as the case may be, shall take appropriate steps to update the credit information within 30 days after being requested to do so. Lordship, there has been another proviso. The first proviso states that provided the credit information company and the specified user shall make the correction, deletion or addition in the credit information only after. Lordships, the council stresses the words only after such correction, deletion or addition has been certified as correct by the concerned credit institution. Here, as per the policies, as per the agreement between the credit information company and its member institution, the nodal officer is the certifying authority. So only if the certifying authority under section 21, that is the nodal officer, if certifies so, the credit information company can update it. However, the same was not in the case of Ms. Pallavi.
Can I proviso over the main statutory provision? Can I proviso under the interpretation of statutes? The first proviso, can I override the main statutory provision from the subsection 3 of section 21?
Your Lordships, it is not overriding, Lordships. It is if it is not
whether both will have to be read together.
They both has to be read together, Lordships. However, if this proviso is not followed, then the section's object will get defeated. The object of the sections will only be fulfilled only if the proviso is followed. In case if it is not a nodal officer, and in case if it is some other person from the bank who is not in, then there will be a flaw, your Lordships. Because nodal officer is the officer who can certify it, as per the member agreement with the member institution, the credit information company. So when it is not done, obviously it is a contravention of section 21, Lordships. Lordships humbly submitted that in case if a credit information company is contradicting this provision, there can be a penalty which can be imposed under section 23 clause 5. So under section 23 clause 5, any credit information company or credit institution or specified user willfully providing to any other credit information company or credit institution or specified user or borrower or claim, as the case may be, credit institution which is false in any matter particular, knowing it to be false, or willfully omits to make a material statement shall be punishable with fine, which may extend to 1 rupees. But in Lordships, there has to be one complaint need to be made by the specific user or by the borrower to the Reserve Bank of India. But that is not done by Ms. Pallavi Ministry. Whereas, as we said before, Ms. Pallavi Ministry is not relevant to the case itself. This is a suo motu cognizance of a report, which is a public report. This is a report on the inherent laws submitted by Mr. Venkatesh Ramasamy. Ms. Pallavi's concerns may be with respect to the Ms. Pallavi's problems, but directly Ms. Pallavi's particular case, as when if she tries to invoke her rights in first name, is not possible through this in this foreign Lordships, because there's already an alternative form. Like she may complain to the RBI, or else she may institute proceedings. And your Lordships.
But she has communicated to the bank through CAC, that
yes, your Lordships.
technical error. She has communicated.
Yes, your Lordship, but however,
Brought to the notice of the CAC through bank also.
The bank, at least as per proviso, at least the bank being the credit institution,
They
would have corrected it,
your Lordships, the bank can give the, as your Lordships may kindly inform in the fact that the banks provide the data, only that they are very raw data, and the data is processed into a form of information, and then that is provided with the credit report, and then the credit report reflects the credit worthiness. So what the credit information companies get from the banks are only the data. However, in case if there has been error in the data, the remedies for the error will be as per an agreement, loan agreement between the borrower and the member institution. So whenever a credit institution is having an agreement with the borrower, in case if any error is made, in case if any default is made by the banking institution, what will be the remedy, what will be the settlement mechanism, everything will be there in the agreement. So CACs do not have an inherent responsibility with respect to what is the relation between the parties and with relation to the borrowers and the member institution Lordships. The Lordships humbly submitted that therefore it's humbly submitted that there are no inherent flaws with respect to the data analytics model, with respect to the research and with respect to the fulfillment of the objects and procedural complications in getting those credit score updated to Lordships. Lordships, there are certain few points. Lordships. Lordships humbly submitted that my learned friends have contended the process of checking the veracity of information. So, in case if the credit information companies has gotten information from the banks and they contend that it is an inherent loss of the credit information company who do not find the veracity of the information also. We are not empowered to find it also because we don't get the data from the borrowers. We get it from only the banking institution. In case if there is any error, the remedy is by the borrower with respect to the agreement they have made. So what we get is only the data, and what we do is only the processing of the information to create a report, and then we give it to the banking institution. So since the object of the credit information company is so important that we protect the financial interest of our country, and we play a very important role in developing the economy of the country, the council would seek that there are no inherent flaws with respect to data analytics model of the credit information company. So ensure that therefore the council seeks if the court is satisfied, the council would move to the credit.
Oh, yeah. Let us assume that few provisions are not consistent. The court has power to read them down or to say them they are violative of the constitution. See, though the entire act may not be held to be invalid or unconstitutional, if few provisions are not going to be constitutional, we can say those provisions are not constitutional. Or if they have to be read down, we will read down.
Yes, Your Lordship, Your Lordship, the RBI, both the RBI and the credit information will be much duty bound to such reading down, Your Lordships, because that will obviously, that will also fulfill the objects of the credit information companies.
But, Mr. Counsel,
Yes,
if you read first proviso to subsection 3 of section 21, that means if the bank has transferred a wrong information to the credit information company, then bank should certify. If you read subsection 3, if the information so received from the bank is correct and it is wrongly reported, then credit institution has to come.
Yes, Your Lordships. But this was not the case in the Pallavi's history. But in case if it is under, if the very data was correct from the bank, and if it is wrong, if the mistake on behalf of the credit information company, definitely in the section 21, within 30 days it can be done, Your Lordships. The update can be done, Your Lordships. The Lordships are satisfied. The council would move to the prayer.
Yes.
Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may please to adjudge and declare that to dismiss the petition and pass any other order, direction, or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, respondent shall duty bound forever pray.
Thank you, Counsel.
It was honor being before the Constitution.
If the Lordships could turn to page number 3 of the fact sheet. Paragraph number 3. Apologies. Paragraph number 3.
The facts.
Yes, of the fact sheet.
Yes.
Your Lordship, it is clearly given here. The assertion was made by both counsels that the decision of lending is on the banks and financial institutions. It is only the decision of the CIC to give them a credit. And the decision to lend is entirely on their own. Your Lordship, it is given in the fact sheet that, quote unquote, banks, financial institutions should include in their credit appraisal process suitable provisions for obtaining credit information reports from one or more CICs so that credit decisions are based on information available in that system. Credit decisions hereby means the lending procedure of the banks. Therefore, the banks are to lend according only to the reports furnished by the CIC. It goes completely against the contention made by the council. The second assertion is with regards to instrumentality of state. The argument made here is that the private company, which is Metafax, is not an instrumentality of state under Article 12 of the Constitution. There are two case laws that the council would like to cite here. First is with regards to Ajay Hasya. In Ajay Hasya case, it is held that a body, a corporate body, or any body, which falls under the definition of other authority in Article 12 if that authority performs a public function akin to a government function. In this particular case, the credit information company collects public credit information. therein that is in itself a public service itself, Your Lordship. Even if
Article 12.
Article 12, that would fall within Article 12. Instrumentality. Under other authority, Your Lordship, not instrumentality, under other authority. And even if it is not falling within the definition of Article 12, according to the BCCI versus Union of India case, a private body which performs public functions can be can be adjudged against with regards to especially violation of fundamental rights, which is the case here. Your Lordship?
When large public interest is involved.
Yes, Your Lordship.
That's what.
Yes, Your Lordship, that is the council request is
Yes.
mistake. Your Lordship, the council also states that.
I think
Yes, Your Lordship.
one unanimity is that, though they have argued, we have argued on the maintainability of the petition, keeping in mind the instrumentality of the state. The whole focus is about the mechanism of the act.
Absolutely, Your Lordship.
Mechanism of the act and how it is being implemented.
Yes, Your Lordship.
So we'll have to
This is-
focus more on that.
Yes, Your Lordship. That contention was raised because that's a maintainability issue.
Yes.
See, any contentions will be raised, they will be repaired. These things will happen in court.
Yes,
We'll
Your
have to
Lordship.
say what exactly is the crux of the matter.
Yes, Your Lordship. Contention, last submission here would be that according to the fact sheet in paragraph 17, Mr. Ramasamy has foregone any personal liability as was admitted by the court counsel. Half a minute, 30 seconds.
Yes.
In this particular case, Mr. Ramasamy had foregone his personal remedy and he had very obviously and explicitly undertaken to resolve the issues of the farmers. Your Lordship, the council would like to cite the questions which have not been answered by my learned co-counsels. The first is with regards to the lack of transparency in the individual's own information. An individual cannot access his own information. And the answer to that is that they are precluded from accessing their own information. Under section 20 of the Act 19-22, according to the councils, preclude a borrower from accessing his own credit information. Number one. Number two, the exorbitant subscription model in this particular case extends from 500 upwards. Minimum rate which has been fixed according to regulations and the Act is rupees 500 per report. This is an exorbitant model which is not even provided for in the regulations, neither in the Act. And Your Lordship, there is no logical answer for the legislative denial with regards to credit history. A lack of credit history is -1. There has been no answer with regards to the same. The only answer here is, if there is a lack of credit history, there is a lack of credit worthiness, which is the assertion which is made by the councils ourselves. We know that lack of credit history means a lack of credit worthiness, and that is the subject matter of the petition. And the councils for the respondents have reiterated that statement. They have not answered. And the last one here would be quote-unquote ordinary financial data. The council suggested that ordinary financial data will be taken for individuals such as farmers. Your Lordships, in paragraph 13 of this particular fact sheet, if it is referred by the bench, last point, Your Lordship. In paragraph 13, it is clearly given that due to poor credit rating, the farmers have been precluded from taking a loan. But in a lot of cases, -1 has been given to those farmers who have not availed the loan. They were not, quote-unquote, they were not considered while arriving at the credit score. Some of the farmers were also first-time borrowers who never had taken a loan and were self-reliant due to sustainable farming model. An individual who is trying to do good by following a sustainable farming model was precluded from taking a loan simply because he did not have a credit history. Therefore, the council sums up his arguments. Deeply appreciated.
The council takes
No,
permission
sir.
to present.
Sorry.
Your Lordship, the council.
Which requires further reply.
The necessity of the statutory necessity imposed by the RBI to procure the FRBI.
So,
Is considered.
you conclude within a minute?
Yes.
Okay.
Your Lordships, as it was stated in the facts, only the procurement of the credit report has been mandated, and not necessarily the credit decisions must be on the basis of the report. The thing is, the reason for such mandatory statutory mandate of the RBI for procurement of the report is that the lending decision must be to ensure the lending decision must be made on the information available in the system. That was the reason, Your Lordships. Your Lordships, maintainability issue cannot be raised during the rebuttal, because it's already been done.
And question of maintainability, don't have much.
Yes, yes. Lordship, exorbitant rating on the commercial subscription policy. 100 annually 1 free report is being available to all the borrowers and then all subscribed users, individuals. And then the 100 rupees nominal, that is also available. Only those who want updates, regular updates, they will only subscribe to the policy. So, obviously. As your lordships, I have proven that the council has proven that there is no conclusive factor, that credit reports are not conclusive factor for the disbursement of the loan. In case if they have they contest the ordinance, they need to provide sufficient evidence as to how much persons, like how much borrowers with negative scores have not been disbursed with the loan, being so financially adequate or they have not considered the alternative data. Otherwise, such contention as a rebuttal cannot be raised. Yes, sir.
Thank you.